Picture this. It's Saturday, cleats on, snack bag at your feet, and an administrator pulls you aside to say you can't coach because a background check flagged something years ago. Your stomach drops. You feel shocked, embarrassed, and suddenly every plan for the weekend shifts. You shouldn't automatically lose parenting time because a background check flags something. There are practical steps to protect your time and your child's routine. Welcome to Danny's Den. Today, we're digging into what those steps actually look like, in plain language, with scripts you can use on the spot, a quick checklist, and yes, a music moment to calm the sideline.
First, the core legal distinction that matters: arrest versus conviction. An arrest is contact with law enforcement. It doesn't equal guilt. A conviction is a court finding. Many schools and some leagues are only permitted to consider convictions or specific adjudications, not arrests alone. So when someone tells you, "We found something," your two immediate questions are, what exactly showed up, and which policy are you applying? To make that more concrete, offenses involving harm to minors or violent felonies are commonly treated as disqualifying across programs. Other charges, minor, old, or sealed matters, often have legal limits on how they can be used. Policies vary by state and by organization, so specificity matters. Years ago, a routine volunteer check flagged an old minor charge, and I nearly missed my kid's game until I sorted the paperwork. That moment taught me two things fast. Paperwork wins you time, and calm buys you credibility. Now, what can organizations actually do? Public schools usually follow district rules and often must give notice or a process before imposing a permanent ban. Private clubs and leagues can set higher standards. If you're told you're excluded, ask for the policy in writing, the specific clause being applied, and an explanation of the appeal process. Getting those answers turns a vague accusation into concrete next steps. Let's practice what to say. Keep it short. Keep it about the child. For an example, I hear the organization found a record. I want to keep our child's routine. Can we review their policy together and agree on a plan for Saturday? For an administrator, please send your written policy and tell me what the check showed. I can provide documents or an appeal if needed. Those lines move the conversation from accusation to action. Anger is normal, but kids watch everything. If you're boiling, step aside and buy time. I hear you. I need 5 minutes to call my attorney, coach, parent before we decide here. That pause preserves dignity and helps later if you need to show the court you tried to resolve things calmly.
Okay, a portable game day playbook, spoken like you're racing the clock between warm-ups. First, carry a folder with your photo ID, any custody order or parenting time paperwork, and proof of any cleared or updated background checks. Second, ask for the program's written policy and the name of the decision maker. Third, if you're denied access, request a written notice explaining why and how to appeal. Fourth, write a quick note after the interaction. Date, time, who you spoke with. Fifth, if your parenting time is interrupted and you can't fix it on site, call your attorney and consider a temporary order to preserve the routine while you sort the facts. Why that paperwork matters. Courts often prefer keeping kids' routines steady, but they also take safety seriously. Documentation shows judges you tried to resolve things reasonably. If a safety risk is real, expect temporary limits while a plan is made. If the policy is applied unfairly, timing matters. Quick action preserves options. Rituals matter. I still belt out a half-tuned walk-up cheer for my kid. It's ridiculous, and I own it. If sideline coaching is off the table, protect the ritual with an alternate role. Ask to manage the roster, run the clipboard, handle the snacks, or be the warm-up playlist DJ. Those roles are visible, meaningful, and keep your kid feeling your support. And yes, wear the Eagles hat. It's symbolic and harmless. Music moment. 2 quick picks I use to reset the sideline. 1, a mellow early 2000s R&B track. Something familiar that invites slow breathing and lowers adrenaline. 2, a steady late 90s, early 2000s hip-hop beat that feels connective and predictable. If Saturday always starts with those 2 songs, your kid builds a ritual that outlasts who stands on the sideline. Before we close,
3 quick takeaways you can use right now. 1. Don't conflate an arrest with a conviction. Ask for specifics and the written policy. 2. Keep that game day folder so you can respond calmly instead of react. 3. Preserve the child's routine by proposing alternative roles while you work through appeals or paperwork. If you suspect unfair application of policy, consult a local family law attorney quickly. School and court timelines move fast. A quick word on language and rehabilitation. Criminal history is part of someone's story. Neutral, non-stigmatizing language and documentation of rehabilitation or supervision plans help move conversations forward. Many programs respond better to a plan than to confrontation. If you'd like templates, a short appeal note, a one-page game day folder checklist, or a script you can text your ex, send me a message. This episode is general guidance only. For case-specific legal advice tailored to your state and custody order, consult an attorney. If you want to talk with me about a particular matter, email Danielle at thelegalassistancecenter.net to book a free 30-minute consultation.
Thanks for spending this game day moment with me. If this helped, please subscribe to Danny's Den for weekly conversations about law, love, parenting, and sports. Next week, we'll talk about money and childcare after divorce. And yes, there will be at least one Eagles reference. Let's keep this community useful and kind. Let's chat.